สวัสดีครับอาจารย์ My name is Surasri Ariyachatvakin. I'm going to make the presentation regarding to my thesis, which is about the infringement of personal data through telecommunication surveillance. In this era, personal data has become an important asset for many private entities. The smart electronic device can monitor their health and daily activities, including the process of collecting of personal data can derive the location such as home or workplace of the data subject, or to monitor people habit and lifestyle. Personal data, especially sensitive data, can be accessed or hacked without owner consent. In Thailand has a number of criminal cases in the area of collecting personal data, causing the jeopardization and violation of sensitive information of person in the society. When there are some group of people called hackers who illegally access into victim data. In the European country has a law called GDPR, the General Data Protection Regulation. GDPR aim to comfort citizens to transfer data from service provider to another, also has the purpose to protect fundamental rights and freedom of individual. GDPR also provides the lawful basis that the data controller or and word processor has to comply with. There was a case in United States. Ring Company and owned by Amazon has contributed the new infrastructure in 2012 called Ring Doorbell. This high technology has the special characteristic that it provides CCTV with the product. The issue is that there are more than 770 police departments in US were working as a partnership with Ring CCL. The official can make the access to the database of every Ring doorbell user and collect the video record without the need of warrant. Due to the warrantless surveillance and the method of collecting record and considered as an illegal method, which is contradict to the human right and personal data protection. According to the personal data collecting of personal data require the consent from the data subject under Article 3 of GDPR. I do agree with the arresting process when the official able to identify the wrongdoer. However, the use of Ring CCL service by the police also violate an innocent people. It deemed that the innocent people have to give the consent automatically. Therefore, I do not agree for the process of collecting personal data because the primary consent of innocent people may not want to give in the first place. In this case, the official failed to consider the right to be privacy of people in the society, and the use of Ring service as a tool for arresting process is illegal. The solution is that the process of collecting of personal data according to the GDPR, the consent has to be clearly declared by the data owner called freely given, which gives the right to the data owner whether he will give or not. Moreover, in my thesis also make a comparative study for the Personal Data Protection Act among GDPR and Singapore PDPA, Thailand PDPA, which mainly discuss about the difference among the law, such as the territorial jurisdiction of GDPR and Thailand PDPA are similar that law personal data protection will be applied to data controller and processor regardless of where activity occur in the country or not. Where Singapore PDPA does not specifically define the personal data geographical location, the PDPA apply to organizations in Singapore processing the personal data where anywhere, and organizations outside of Singapore processing personal data from individuals in Singapore. Unlike the GDPR, is the PDPA does not limit the scope of extraterritorial jurisdiction based on the nature of data processing activities. Thank you for your attention.